Welcome to episode 68 on the law rapport. Today I'm going to deal with something a little different than I usually deal with on this channel. I'm going to depart from my usual criminal law and I'm going to discuss something in the area from contract law. And I'm going to discuss specifically what is called in contract law an invitation to treat. So the issue here is that I've met a few people who have complained that they have gone to a supermarket, and I wouldn't call the name of any supermarket, and goods are advertised at a certain price, and when they reach to the cashier, the goods are really for a higher price than it was advertised as. And they are of the view that the supermarket or that the seller was attempting to rip them off. They have not actually asked my opinion. They have not asked how I felt about it. So I offer no view on the matter. I just listen. Today I'm going to discuss that issue generally. But before I do, my usual disclaimer: this is not legal advice, should not be construed as legal advice. For legal advice, please contact an attorney of your choice. Welcome back. So, does a seller have to sell a potential or prospective buyer goods for the sum that was initially advertised? And if the seller insists on a higher price, is the seller running a scam? The short answer to that, in my considered opinion, is no. Generally, advertisements are not offers, but what is called in law invitations to treat, and that's TREAT. So a person advertising is not compelled to sell, or he is not compelled to sell. And when I say he, I mean he or she is not compelled to sell at the price for which the good or goods was advertised. In the case of Partridge and Crittenden, 1968, a defendant was charged with offering for sale protective boards, which were bramblefinch cocks and hens that he had advertised for sale in a newspaper. It was held by the court that he was not offering them for sale. Lord Parker, Chief Justice at the time, said it did not make sense or make business sense for advertisements to be offers, as a person making the advertisement may find himself in a situation where he would be contractually obligated to sell more goods than he actually owned. In certain circumstances, called unilateral contracts, an advertisement can be an offer, as in the case of Carlyle versus Carbolic Smoke Ball Company in 1893, where it was held that the defendants who advertised that they would pay £100 to anyone who sniffed a smoke ball in the prescribed manner and yet caught influenza were contractually obliged to pay £100 to whoever accepted it by performing the required acts. But that is a different circumstance. What I'm concerned here with are goods displayed for sale, whether on a shop shelf, a supermarket shelf, or a shop window. In the case of Pharmaceutical Society of Great Britain versus Boots Cash Chemists of 1953, generally referred to as the Boots case, which is the leading case in this era, the defendant ran a self-service shop in which non-prescription drugs and medicine, many of which were listed in the poisons list provided in the Pharmaceutical and Poisons Act of 1933, were sold. These items were displayed in open shelves from which they could be selected by the customer, placed in a shopping basket, and then taken to the till or the cashier where they would be paid for. The till was operated by a registered pharmacist. However, the claimant brought proceedings against the defendant for breach of Section 18(1) of the Pharmacy and Poison Act of 1933, which required the supervision of a registered pharmacist for the sale of any items in the poisons list. The issue in this case, and the question to be answered, was whether the contract of sale was concluded when the customer selected the product from the shelves, in which case the defendant was in breach of the act due to the lack of supervision at this point, or when the items were paid for, in which case there was no breach due to the presence of the pharmacist at the till. The court held, and this was the Court of Appeal, that the defendant was not in breach of the act, as the contract was completed and payment under the supervision of the pharmacist. The display of the goods on the shelves were not an offer which was accepted when the customer selected them. Rather, the proper construction was that the customer made an offer to the cashier upon arriving at the till, which was accepted when payment was taken. This analysis was supported by the fact that the customer would have been free to return any of the items to the shelves before a payment had been made. And this so when a person takes goods from a supermarket shelf, put them in the trolley or the shopping cart, there's no contract at that time. The person has not entered into a contract with the supermarket or the supermarket owner. But when the person reaches to the cashier and pays for the goods, then that is a binding contract, because at any time before the customer pays for the goods, he could return the goods, he could take it back to the shelf. He could say, I don't want this anymore. So an invitation to treat normally is an invitation to enter into the shop to do business, or the supermarket to do business. It is like an enticement to come in to shop. You like the prices that you see from the show window? Come in and look around. But you're not under any obligation or any binding contract until you approach the cashier and pay for the goods. And so, for those who are of the view that if the price and the goods on the shelf are different than the price quoted to them at the cash machine, that businesses are trying to rip them off. It's a fallacy in law. Also, in the case of Fisher and Bell in 1961, the display of a flip knife for sale in a shop did not contravene legislation which prohibited offering for sale an offensive weapon. If a shop mistakenly display an item for sale at a very low price, it is not obligated to sell it for that amount. For an offer to be capable of becoming binding on acceptance, the offer must be definite, clear, and objectively intended to be capable of acceptance. And we have seen this many times. For example, there are laws against selling alcohol on Sundays. But when you go into the supermarket, there's still alcohol on the shelf. The display of alcohol on the shelf is by no means a contract between the prospective buyer and the supermarket to purchase the alcohol. And the supermarket cannot be held liable for offering alcohol for sale on Sunday. But if someone takes up a bottle of wine or a 6-pack of beer and then goes to the cashier and pays for it, and the cashier accepted payment, then the supermarket, in my respectful view, will be liable of selling alcohol on a Sunday, which is prohibited by law. I hope I have been clear in this episode. I believe that it is a very interesting one. If you find it interesting too, please like, share, and comment. And if you have any questions, please leave it in the comment section below. And I will see you in another episode. But most importantly, I thank you for taking the time out to view this video. Thank you again for watching.